The Legal Cheek podcast is sponsored by Simpson Thatcher, home of the private equity training contract. Hello and welcome back to the Legal Cheek podcast. My name is Julia Szaniszlo, a writer and editor at Legal Cheek, and a warm welcome back to my fellow writer and co-host, Ryan Scott. Hi, Ryan. Lovely to have you back.
Hi, Julia. It is lovely to be back to the usual programming.
Very nice. So, for all of you eagle-eyed Legal Cheek podcast fans, you may remember that our very first episode of season 6, last December, covered the topic of merger mania. At the tail end of 2025, the legal sector bore witness to not one, but 3 major law firms announcing transatlantic tie-ups. And in that episode, we explored what reasons could lie behind such major strategic trends. But it's all well and good announcing a merger. What happens once the ink is dry on the proverbial page? How does a merger actually work in practice between law firms? And what issues could arise when combining firms which on paper seem compatible, but might actually be more different than you think? We can't promise to give you all the answers, but we're going to try and do a little bit of that today. So to bring you up to speed, the 3 major mergers that I've been talking about, major mergers, are Ashurst and Perkins Coie, which went live a few days ago. Winston Taylor went live in early June 2026, and Hogan Lovells Cadwalader goes live on day of recording, the 1st of July. So that's today. We might release tomorrow. And this is obviously one of the largest mergers, I think, if not the largest mergers in law firm history. So just to give you a quick overview of what the facts are for each of these. So for Hogan Lovells Cadwalader, the combined revenue is estimated to sit at around 3.6 billion US dollars. There are around 3,000 lawyers now in this law firm, and its rank by revenue has put it up to 5th, which is huge. Ashurst Perkins Coie is sitting at a comfortable $2.8 billion, with also around 3,000 lawyers, and is comfortably also within the top 20. Winston Taylor is the smallest of the 3, with a number of lawyers sitting at around 1,400 and a combined revenue of around $1.75 billion as well. Each of the mergers has a slightly different structure, slightly different leadership. So we'll get into that later on. But it's worth noting that most of these mergers, the reason they happened was because they were all trying to gain a foothold, a deeper foothold in the US market, expand their reach into different practice areas and different geographies. And if you want a bit more of insight into how all of that panned out and how it sort of worked in more detail, please go check out our episode on that, which is called Merger Mania, Season 6, Episode 1, if you scroll back in our Spotify or our Apple podcasts. But how is this all going to work? What happens when these mergers, finalize, which they all have now as of today? What sort of challenges can arise? The obvious practical stuff, which you may think people think is, completely obvious, like branding. What happens to all of the employees? What happens to the governments? And obviously that big word, culture. So we're going to answer some of those questions today. And I'll hand over to Ryan first to talk about the fun bit, branding and all of that good stuff.
Yeah, so I think one of the biggest challenges, obviously, settling on a new brand and identity for the law firm. With a merger comes a change in logo, change in website, promotional materials, name, visual identity, social media, email addresses, everything needs updating. Just to touch on 2 of the examples you gave of Ashurst Perkins Coie and Hogan Lovells Cadwalader, Ashurst their new site went live yesterday or the day before, sometime this week. And it went from Ashurst's orange and white kind of signature colours to Perkins Coie. Well, Perkins Coie had a navy and white background. And it's now it's not like any of them. It's a sort of like cyan colour and a completely different font. Each to their own, I'd say. And then you got Hogan Lovells Cadwalader, which is it's kind of a merger. It is literally like a merger of the 2 firms' logos and existing branding. They've adopted kind of a similar font to what Cadwalader used, but adopted the colour scheme of Hogan Lovells and retained that kind of black and green colour. Some additional considerations are also just to do with trademarking your new name, registering your new name, protecting it, and also just like changing the signs at all of your offices. Like that's going to cost a lot of money, and quite quickly, all this kind of new these marketing materials, these new brand and identity things, it's going to start racking up money. Just whilst we're on the topic of the new name as well, even something as simple as a name can send a message about who has kind of like an upper hand in the merger. It sounds quite simple, but it can be quite kind of like a political decision. So a name could mark that a merger is of equals and retain both of the legacy firms' names. So Ashurst Perkins Coie, you got Ashurst and Perkins Coie, and then same with Hogan Lovells Cadwalader, you see both the original firms. But in 2017, Norton Rose Fulbright merged with, I think it was a New York-based firm called Chadbourne and Park, and they just decided to keep the name Norton Rose Fulbright and didn't add in any of the kind of Chadbourne and Park in there. So that probably indicated that it was a much smaller firm. It was a bigger firm swallowing up this firm, which might be distressed or just considerably smaller that doesn't make as much of an impact. Another thing to think about when there's a merger is kind of the office footprint. So if two global firms are merging, like the ones we've discussed, the merged firm might suddenly have multiple offices in the same jurisdictions or the same locations. And that raises a lot of practical questions like, do we keep both offices open in the same locations? Do we move everyone into one building? Where are we going to place our HQ? And there's been a lot of different responses to these questions, and I want to keep on the theme of talk about Hogan Lovells Cadwalader and Ashurst Perkins Coie because there's some good examples here. So Hogan Lovells Cadwalader has two office locations now in New York. The first one was Cadwalader's HQ on Wall Street, and the second one was Hogan Lovells' well, just New York office in Midtown. They're both close to their kind of like large institutional banking and private capital clients, and they've decided to keep both office locations in New York open. And I don't really know the geography of New York that well. Don't know how much of a difference is between Midtown and Wall Street, but they are next to very big clients. Like I think JP Morgan's across the road from the one in Midtown, and in Wall Street they're across the road from Goldman Sachs, which I could be wrong, but I believe they were clients of both the two kind of legacy firms beforehand. And then you've got Ashurst Perkins Coie, where Ashurst and Perkins Coie both had offices in London. Ashurst moved into their office in the London Fruit and Wool Exchange, I believe it's called, in like 2019. It's a really nice office if you ever walk past it near Spitalfields. It's quite big. Nice and open, very beautiful office. And then you got Perkins Coie. Never seen Perkins Coie's office, but I believe they only have about 20 or so lawyers at their London outpost. So it made a lot more sense for Perkins Coie to move in to Ashurst's HQ in London rather than get a new office when their offices are all already relatively new, don't really need an upgrade, and it can accommodate these only 20 plus lawyers in London. And then just another point as regards HQ. Ashurst Perkins Coie's kind of gone a bit of a unique route. Instead of deciding on having one single HQ, because one of them's in like a US based firm, one of them's a UK based firm, they decided that they're going to have flagship hubs instead in kind of like the major cities that have got Seattle, London, Sydney, and New York. And these kind of reflect the histories of both the separate firms as well. So Ashurst was itself born out of a merger with Ashurst, which was like a UK-based firm, and Blake Dawson, which was like an Australian firm. So they have a big office, they have a big presence over there as well. So that's why they've got the offices in London and Sydney, and the flagship offices there. And then for Seattle and New York, you've got Perkins Coie's kind of expansive reach all across America and offices all over America. I think it was born out of Seattle, and then you just want an office in New York because that's where all the money is. Um, just to wrap up on this, with office space as well, having excess office space can be a bit difficult because leases are difficult and costly to exit. And you kind of got to decide what you want to do with that extra office space. If you have it, are you going to sublet it to someone else, or are you going to retain it until the end of the lease, or just retain both of them? That's a large cost. And then finally, on the branding point is market perception. So how are you, as the merged firm, signaling and positioning yourself in the market? A law firm probably wants to control the narrative of how the merger is being kind of pitched to the public. You can say, this is a sign of strength. This is a growth story. We're doing it as a response to changing client demand. We're attempting to compete with US firms, or we're now a full service firm with true international depth. I think one of the best examples of this, and it probably wasn't, it's not really to do with a merger, but just to do with branding and identity in general, is with Freshfields. They like disclaimed the magic circle term quite a while ago now, and say that they want to join the global elite. So in kind of becoming a merge firm, you want to signal to your clients and to the rest of the public where we are in the market. Are we now a transatlantic firm? Are we a full service firm with depth all over the world, whatever it may be? And you just kind of got to decide on the strategy there. But yeah, just moving on to you, Julia. Do you want to talk about some of the kind of differences in financials between some of the merged firms and how that might cause problems?
Yeah, of course. So I think that's what you usually see in the headlines when law firm mergers are announced. People really focus on global revenue as a marker of the value of each firm and, how much control each firm is going to have over the new entity. And the sort of cliche, because all of these tie-ups are transatlantic in the sense that one firm is predominantly US headquartered or is a US legacy firm, and then the other has its roots in the UK and beyond. So I think, it's clearly sort of there's this transatlantic trend. And the cliche is that US firms are obviously tend to be more profitable, often because of the kind of work that they do. So very high value finance, M&A, private capital work, and the leaner associate numbers. So even slightly smaller US outfits can compete with or outperform its cross-Atlantic, its cousins across the Atlantic. And that means that there are some like gaps in revenue, or more, equal revenue where you wouldn't expect it. So just to give you an overview, for Ashurst Perkins Coie, I think it's the cleanest case of equals financially. For instance, the PEP, so the profit per equity partner, was really close actually between the two, sitting at around 2.1 million for Ashurst and 1.9 for Perkins Coie. And the revenues were also fairly similar, sitting around 1.2 billion for Ashurst pounds and $1.3 billion for Perkins Coie. I'm not going to do the conversions right now. Yeah, no. So it has been framed as a sort of merger of equals in that way, because there's a lot of parity there. And I think actually that explains the combined, very changed branding. They decided clearly to go for a fresh start, I think, because they want to be seen as something completely new. And that makes things a lot easier, I think, just to turn back to the financials, because there's no major difference between partner pay or partner average equity. And there's not going to be, I think, as much friction. There'll obviously still need to be conversations about where that medium is going to lie, because there are some mild differences, but it's not as much of an issue with, as with like Winston Taylor, where the difference is quite stark. Taylor Wessing, the sort of one side of the merger, is a lot less sort of profitable than Winston and Strawn's US partners, who earned a lot more. For Hogan Lovells Cadwalader, Cadwalader is obviously a smaller, specialist, finance-focused firms with a, very high profit margin, very high performance, but it's just more, narrow. Whereas Hogan Lovells is this huge, generalist firm that does have very, very good profitability. But, the other thing to bear in mind with these financials is that they affect junior pay. So for Hogan Lovells, I think the disparity was quite a big one for Hogan Lovells Cadwalader, the disparity between how much its trainees are being paid and Cadwalader's trainees were being paid is quite large, and the firm has yet to announce where that's going to lie or where that's going to fall. For the first couple of years after a merger, the sort of agreements, the trading contract agreements, tend to be honoured if they were agreed upon before the merger went live. But, eventually they're going to have to choose where they're going to end up and how that's going to, pan out. But yeah, I'm curious to see where they decide to land on that. It's hard to tell. I think, we've seen actually, lots of mergers haven't actually resulted in a much more profitable firm. I think I read somewhere that of this sort of 18 largest law firm mergers over the last 15 years, only 2/3 grew their PEP and revenue per lawyer. I'm sorry, 2/3 grew their PEP and revenue per lawyer more slowly than their competitors. And Hogan Lovells, ironically, was the product of a merger that has actually been quite successful financially. So it'll be worth seeing whether this pays off as a financial gamble. It's all a bit up in the air at the moment, but financial disparity is probably the biggest talking point that people come to, because it throws out the debate of whether is this a merger of equals or is this actually just a covered up acquisition. And I think there's a lot of debate around that with some of these firms. But other than just the money that you have beforehand, law firms need to keep continuing making keep to continue. Yeah, law firms need to continue to bring in business, and they do that with their clients. So this is also going to cause some issues. Ryan, do you want to talk a little bit about that?
I do indeed. I want to speak about clients and conflicts management. And I hope I don't seem too distracted, but there's a fly who keeps kind of steal the spotlight and hijack
Oh,
the camera. And he is
rude.
just, they are really annoying me right now. But alas, we shall carry on. Yeah, so the bigger the merged firm becomes, the more likely conflicts are. One of the kind of key things a lot of firms go after in a merger is kind of scale, so depth of kind of client bases and expertise, but kind of also creates more restrictions because the bigger both the firms are, the more likely there's going to be you're representing firm A is representing one client and firm B is representing someone they're going against in like a case or they're on the other side of a transaction. So firms will spend months in advance of the merger trying to manage these client conflicts so as to minimize any problems later down the line. I think we should just start with like a, I don't know, basic definition of client confidentiality. So law firms owe duties to all their clients, like duties of confidentiality and loyalty. And as I say, when two law firms merge, their client list will be combined. Say, I don't know, firm A was acting for JP Morgan and firm B was acting for Goldman Sachs, and it was in a case against each other for some reason. If firm A and firm B are planning to merge, it's going to cause a bit of an issue because they're representing people on either side of litigation. So what can you do where there's like a client conflict like that? There's various options. The first and the most common one is to stop acting for one of the clients. And that will be a decision the merged law firm takes based on which relationship they consider to be more valuable or maybe strategically important to the firm, or which one's the most long-standing relationship, who they're most loyal to. Um, Obviously, it's a difficult one because if you're representing two big like institutional clients or two big fintech clients like it sometimes is, then it's kind of hard to decide which client to drop there because they're both probably bringing a lot of money, and obviously you're ultimately losing out to a competitor. Um, Another option is to finish all work for one of their clients ahead of the merger. So a legacy firm may try and wrap up any outstanding matters they've got open with one of their clients, or they might stop accepting new instructions from one of their clients months ahead of the merger. So basically, they can hope everything is tied up in advance. Another option is to delay the merger until all the work is done for one of the clients, but unless a client is like hugely important to a firm, I doubt that will happen because you obviously have lots of clients at these big firms. You may also obtain in some circumstances something called late informed client consent. However, it's not always possible, and many clients don't find the prospect of giving it attractive, so that's not given very often. And another possible alternative where there's a client conflict is like information barriers. I think I've seen them being called Chinese walls as well, or ethical walls. And it's just where you create like strict internal barriers between your teams so that they are physically and electronically separated. Files can't be accessed by members of kind of like the other legacy firm, and lawyers can't discuss the matters between each other, and there's different supervisors on each case. So basically the conflict is trying to be avoided as much as possible as within the firm internally, but that's kind of hard to maintain, and I also don't think it's very popular with clients. um, just in terms of some other issues as well from a client's perspective, other than conflict management, one of the things I might look at is fee harmonization. So firms might have different charge out rates, especially where one's US based and one's UK based, and the firm might have to make decisions as to whether align fees. Clients might resist if the fees are increased, and partners might resist if they have to work for a lower rate. Another issue is just with client retention more generally. A client might worry the firm becomes too big, less personal, or too expensive. They might wonder whether they're going to deal with the same partner, the same team, whether it's going to be the same office. And as I said before, they might worry that the fees are going to change. In my practical experience of a merger, so I went through one when I was a paralegal between two regional firms based out of Hull. Um, as regards the client retention aspect, we kept clients informed throughout the entire merger process, kept emailing them, kept contacting them to say, why are the mergers happening, where we're at in the merger process, and when it's going to go live. We gave clients, I think, a dedicated contact for any inquiries or questions or concerns they have. And we also reassured them that any existing matters wouldn't be disrupted. Another thing we did as well was address conflicts by reviewing all of our active matters before the merger completed, and we went to go see if any of the other firm was acting on the other side of any of our open cases. And if we did, we went to go flag any potential conflicts to a conflicts partner, we called them. That was usually just our head of department, and they'd take it up with someone else within the firm. I'm not sure who. But yeah, it's firms spend months and months doing conflict management before it goes ahead because it can be big regulatory consequences, or you're losing out on big clients otherwise. But yeah, Julia, just moving on to our next challenge. Do you want to talk about governance and leadership in a merge firm?
Yeah, absolutely. So another important aspect to consider when two firms merge is who's going to steer the ship and how is that going to look. And this includes things such as the structure of the board, voting rights, any sort of regional autonomy, who leads the practice group. So if you've got two global M&A chairs, who's going to be the chair, or are they going to be co-chairs? And this, informs whether or not people consider it a merger of equals, as is, pretty obvious. So just to run through how the firms that we've been discussing have actually landed, Ashurst Perkins Coie, as it seems to be the case, is the most close to a merger of equals. So they've explicitly described it as 50-50 in a lot of their press releases. So all profits are being pooled and it's going to be fully integrated. And this is also reflected in their two co-CEOs and co-chairs. So there's one drawn from each of the legacy firms. So that's pretty straightforward. They've done a bit of a split down the middle. However, that's not the case with some of the others. So Hogan Lovells Cadwalader, it looks a little bit more like a large firm is absorbing sort of a smaller specialist, even though, of course, Winston Cadwalader, sorry, was very, very profitable. So the Hogan Lovells leadership will mostly remain in place, whilst Cadwalader will get 4 seats on a 21-member sort of international management committee and 2 on a 13-seat board. So the name is joint, but the governance is quite different. Although, as far as I know, yeah, sorry, that seems to be good. And then for Winston Taylor, is like a partial combination, obviously, because only Taylor Wessing's UK-led business and the Netherlands and Belgium is joining, whilst the sort of Swiss Verein are leaving. The Swiss Verein, sorry, is being split, and it's leaving sort of 230 plus German partners to form a separate structure. So that's just going to make the partnership look quite different. But Winston and Strawn's chair is going to continue. So that tells you quite a bit about, I think, their financial firepower, maybe, or maybe the fact that even though they're a much smaller firm in certain respects, they're going to hold a lot of that control. Sorry, I almost messed up for a minute and I had the thought like, oh my God, is Cadwalader's CEO leading? No, it was Hogan Lovells CEO's leading and Winston Strawn's chair is continuing on. Yeah, but this just essentially means that when you're reading the legal press and you start seeing news about these mergers, it's good to sort of interrogate who's leading where, how they're actually going to structure this sort of leadership, who's going to have all of that decision-making power. What's the board going to be composed like? Because this has a big effect on, massive decisions. If the board is predominantly made up of people from one firm, that could lead to that firm's culture taking over more or having more weight, in the way that the firm is run day to day. And I think that's quite important. Ryan, do you want to move on to the sort of regulatory side of things?
I will indeed. This one's a bit of a smorgasbord of topics, so I do apologise. I just want to talk about structure, regulation, and compliance. And I appreciate Julia spoke about structure there, so I shall rush through it. But a law firm merger is not just about putting a new name on the door. You have to build an entirely new legal structure behind it for this new combined firm. And some of the key questions to think about will it be one global partnership? Will different countries remain separate legal entities? How will profits from partners flow around the business? And who actually owns the merged firm? So as Julie mentioned there with Taylor Wessing and Winston Strawn, the UK arm of Taylor Wessing exited the Swiss Verein and they joined with Winston Strawn and kind of left the others behind. And that's just a consideration you've got to think about in what will this new merged firm look like in terms of legal structure. Another thing to think about as well is partnership rules. So law firms are usually owned by their partners. Most firms take the structure of like an LLP. The mergers mean combining two or more groups of owners because partners own the firm. So they need to agree on like new partnership rules, like things including voting rights, profit sharing, rules as regards requirements, retirement, and like capital contributions, and how new partners will be admitted. Another thing as well is approvals. So law firm mergers are subject to a partner vote usually, and there'll also be some pre and post merger kind of approvals and steps that you have to take with the relevant regulatory bodies. So in the UK, that'll be the SRA, but with these global law firms, obviously they operate in all sorts of jurisdictions. They'll probably have to take a lot of regulatory steps with the relevant regulatory body in that jurisdiction. I mean, one of the things I think you've got to remember that is easy to forget about is that law firms actually hire law firms to represent them in the merger. Um, I'm not actually sure who's representing Ashurst and who are representing Ashurst and Perkins Coie, and same with Hogan Lovells and Cadwalader. I might have a Google in a minute to see, but it's quite interesting to think that law firms do not represent themselves in these cases. Um, and then also you got to think about due diligence and managing any inherited risk. So just like a normal merger, firms have to do the due diligence to flag any issues that they might inherit. So think about kind of negligence claims against the firm or any open regulatory investigations to do with kind of money laundering or any other sort of like compliance issues, sanctions, stuff like that, or whether there's any employment disputes open. And then it's also important to think about professional indemnity insurance. All law firms have to have professional indemnity insurance, and you've got to make sure that the new firm has the same insurance and that it covers any historic work or ongoing claims relating to the legacy firms as well. And then finally, just to do with some other compliance aspects, this is all the kind of boring, dry part, but this actually probably takes up most of the time of the firms when they are merging and a lot of the thinking power as well. They've got to think about all the compliance systems they have in place, like anti-money laundering systems, sanctions, kind of procedures, and cybersecurity. I mean, kind of a breach of any of these can lead to massive fines. Like you see some of the firms who have breached like anti-money laundering provisions be fined hundreds of thousands because of that. So the both the firms when they come together need to align those procedures and systems. Otherwise, they may expose themselves to some regulatory risk. So Julia, do you want to tell us about the kind of people and employment issues as regards law firm mergers?
Yeah, of course. Thank you, Ryan. I think I'll start with the topic that's sort of closest, most likely to our listeners' hearts, the junior lawyer perspective on mergers. So imagine you are a future trainee at Ashurst and the merger's just completed. What's going to happen to your pay? What's going to happen to your entire training experience? You're suddenly being, with Ashurst and Perkins Coie, maybe the difference isn't too large, but it is pretty significant. So how's that going to impact your very vulnerable and early, first period in your career? So the good news is when a merger completes, firms normally, generally honor their pre-merger training contract offers. So you're going to have like a collision between two intakes. So Ashurst, for instance, on the one hand, and Perkins Coie on the other hand. And so the qualifying cohort will usually be a little bit confusing. They'll be larger, and it might result in some dips in retention. And I wanted to look back in history to give you an idea of how this can affect law firms by looking at A&O Sherman. So obviously pre-merger, known as Allen and Overy and Sherman and Sterling. So Allen and Overy previously offered 80 training contracts a year, and Sherman and Sterling only offered 12. So the first post-merger retention round, they just combined their cohorts, came in at 66%. So only 37 of 56 trainees were retained. This is very understandable because imagine you've signed up for a small US training contract with, lots of interaction with teams and lots of personal interaction with higher ups, lots of early responsibility, Sherman and Sterling, and suddenly you're subsumed into this cohort of 92 people. That's not really what you signed up for. So maybe you're going to want to move on afterwards to get a little bit of that US flavor back. There may be lots of other reasons, but that's one of them. Obviously, it bounced back after this. So in July 2024, there was that 66% retention rate. Then it came to 84 and then settled around 69 and then back to 76. That's until spring of 2026. So it's good for sort of preempting that whole mergers are terrible for trainees. reading because it usually evens out. However, it depends on how big the differences are. So to look at the ones that we're looking at, Ashurst Perkins Coie, pre-merger, Ashurst was running 38 London training contracts, and Perkins Coie only had 4. So imagine that cohort size. Ryan mentioned that there are only 20 lawyers potentially in Perkins Coie's London office. So this lopsided intake has, set the new entity up for probably a bit of a dip. We'll need to see. We don't know. That might be just me being fear-mongering. But the difference is quite large. And then obviously pay discrepancy. So let's look at Winston and Taylor in that case. The NQ and sort of trainee pay was still unconfirmed when the merger went live. Pre-merger, Winston and Strawn led, understandably, as the US counterpart, with trainees earning £56,000 in their first year and 61 in their second year, and 160 on qualification, versus Taylor Wessing sitting at around 52, then 57 and 115. And it's that NQ salary difference that's quite stark. So the question is, where's that pay going to go? Is it going to even out? Are they going to stick to their respective pays for a couple of years whilst that cohort that applied pre-merger comes, up through the ranks? Hogan Lovells also hasn't yet announced what they're going to do with their pay discrepancies because they also have them. So this is worth bearing in mind. If you are a trainee who applies to a firm that suddenly merges, you may suddenly be in a cohort with people who are earning either £40,000 less or for £40,000 more than you once you qualify. And that can, be an issue for some. On the other sort of end of the spectrum, not just for trainees, but just general employment issues, any sort of overlap with roles, whether that's in business services, HR, finance, marketing, all of the non-lawyer roles in firms may cause duplicate or create duplication. So you might end up with multiples, of the exact same role. And this isn't obviously like a headline making topic, but it could affect far more people than just like partner moves, because the whole point of a law firm merger is to get more lawyers. They're not combining assets in the same way that like two factories merging might do, with their different facilities and whatnot. The whole point of the merger is geographies for law firms, is geographies and lawyers and expertise. For Ashurst Perkins Coie, for instance, they're sort of reorganizing into 8 separate divisions, and this may, throw up some duplication in certain aspects, which may lead to redundancies, and that can be a really stressful thing to experience. It's a common thing. I think there was a scene in Suits, not to bring Suits up, and this is probably completely unrealistic, but when they were advising on a merger and they had to, as lawyers, come up with a list of people to make redundant because there was just a lot of duplication from both sides. And, that's quite an unglamorous and unpleasant question, but it's one worth thinking about. And I think you're going to get onto this, Ryan, but there are also just other practicalities when it comes to just people working. The sort of unspoken rule of like communication styles, the sort of invisible and unwritten infrastructures and rules around like how you respond to emails, who has decision-making power. Excuse me. If you're like a US firm, you're used to lots of independence in the US firm's London office because it might just be a trainee and a partner working on a matter. What happens when there's suddenly a lot more bureaucracy involved? And this is an extremely difficult thing to merge because it's very murky. But yeah, do you want to discuss a little bit about these sorts of systems, whether the official ones or the unofficial ones?
I will. I will just touch upon the thing you said about suits as well. From my limited knowledge of employment law when I did it at uni 3 years ago, there are kind of redundant. You got to follow proper redundancy, a fair and proper redundancy procedure when you're making anyone redundant. If you're making, it was more than 20 when I was at uni. It might have changed now, but if you're making more than 20 people redundant, there's something called collective redundancy obligations where you kind of got to notify trade unions, and there's all these other sort of protections in place. And most of the time, like if it's a big firm, if it's two big firms coming together, they'll have so many duplicates of back office functions across the globe. Like you don't need 2 HRs, you don't need 2 business development teams, you don't need 2 grad rec teams at every single office. So there might be some redundancies there. I think some law firms do put like press out saying that we aim to, or we're not going to make anyone redundant, which kind of gives them a, I guess, a better reputation in the eyes of like the public, and also just secondly, like it assuages any fears of people working there that they're not going to be made redundant, which is nice. Um, but is sometimes like a an inevitability that does have to happen, sadly. But yeah, just moving on to kind of technology systems and internal operations. So every law firm has its own kind of tech ecosystem. When two firms merge, those systems won't match, and they need to find ways to kind of align those processes, decide which systems to keep, which to replace, and how to move every single body everybody at the merged firm onto these systems. So just in terms of like the type of tech a firm will use, so we got subscriptions to legal resources like LexisNexis and Practical Law. You've got subscriptions to legal tech platforms like Harvey and Legora and all the rest. There's hundreds you could name, a lot I could, but there are a lot. Case management systems, which is something law students might not know a bit about unless you've been in practice. I will cover that in a second. Billing and time recording software, and then just general software packages like Microsoft Word and Adobe. You use a lot of PDF readers and PDF compilers, I guess you'd say, editors, in practice for tasks like making bundles and stuff like that. And it's actually really difficult to use if you've never done it before, and it can take a while to get accustomed to or used to. So when you're replacing that, especially with not to kind of generalize, but if you've got some older people in the firm, much more senior people who kind of didn't grow up with this sort of technology in a sense, it can be more difficult to get them to kind of relearn and reuse the technology as quickly as efficiently, I guess. But yeah, just talking about case management systems first of all, it's a sort of like digital filing cabinet, is I guess the way you'd explain it. It contains every single one of your cases, and whenever you receive a new instruction from a client, you would open a new matter in this case management system. You'd then upload all relevant documentation to it, so literally anything relating to the case. So pleadings, witness statements, it could be land registry documents, any other sort of evidence that needs to be on there, you'd upload it to the file so you can access it easily. And it will also contain tools like conflict checkers to ensure there's no conflicts with any other clients you're acting for, and like anti-money laundering tools that you've got to make sure basically that you've got your client's passport, you've got the client's, I don't know, the company documents to make sure that you're actually allowed to act for these people, stuff like that. Um, so case management systems are very essential. You use it every day. It's where you contain all your cases and put all your updates and all your deadlines for going to court, etc., etc. But they can be very technical and difficult to use. And firms use different case management systems everywhere. It's very unpopular and it's seen as unfair to abandon one of the case management systems, but it simply doesn't make sense in kind of a merged firm to use two separate systems entirely for one of the legacy firms. Like you just need to align them. From my own perspective, when we went through a merger, as I say, I worked for a regional firm which merged. We fortunately were the bigger firm and we kind of stuck with our case management system. We had more people on it, more people used to it. But the other firm we merged with, there was constant grumbles for months about how hard it is to use, how it's unfair that they had to move to our case management system and not us to theirs. Quite a lot of the partners complained about them having to relearn it and waste their precious billable time trying to figure out kind of the basic functions all over again. So it can take, I would say, at least a few weeks to months before you get fully used to it. And like, because if you're working on the same case management system for years, it becomes second nature to you. It was like me making the transition with my uni notes from Microsoft Word to Notion. That was a big jump, but I made it and it took me a while to acclimatize, whichever one the word is. Alas, there's a lot of practical solutions you can do here. You've got dedicated IT teams at all the firms to give you kind of training sessions, or you can bring in IT consultants, help people resolve any queries about the new systems, give kind of presentations and seminars on how to get to grips with them quite quickly. Um, and then another issue as regards like technology and IT integration is about data migration. And it's something I don't think you naturally think about. It's just about obviously moving data from one system to another, but moving decades worth of client data isn't just like, I don't know, copying files onto a floppy disk or onto a USB stick and transferring it to another firm. You've got millions and millions of client emails, probably at the big firms as well, like hundreds of thousands of clients and cases that are open. You've got precedents, which are just kind of like examples of different forms you'd use. So basic, like, I don't know, contracts drafted by your firm that you'd rely on when you need to draft a contract. Um, Same with billing information, just there's certain information that you've got to retain for so long as a law firm. So you've got to transfer all that over. The challenge is that data migration is a very long and arduous process. And whilst it's getting done, it can lock lawyers out of their account for several days at a time or require them to like just, I don't know, be offline whilst it's getting done. Remember at my firm, we tried to do it on like a Friday evening over the entire weekend. We had a long weekend, it might be an Easter holiday or something like that. So no one was really on their laptops at home. So it just meant data migration could have gone more smoothly. But I imagine at a bigger firm, it was like lot longer and be a lot bigger of a task. And then finally, just with billing and finance systems, every firm records time and bills time slightly differently. If lawyers don't know how to record their time, they can't bill their clients properly, and each firm will have different systems in place that need aligning. You have things, at least at my old firm, we had things like client codes, which was like a specific code assigned to like regular clients we use, and matter type. So whether it was litigation or transactional or whatever it may be. And there's all these codes that you come into contact with, I guess, every single day and you kind of remember them. But if you're merging with another firm, it's all going to be completely new and you need like some sort of guide or someone to help you with that. And I imagine the finance people get a lot of calls when the very first merge and it's probably very difficult for them. So yeah, there's a lot of back office, well, like IT and systems functions that we you don't tend to think about that are a little bit more boring, but will definitely take up a lot of time when the merger is getting effected. And Julia, do you just want to move on to cultural integration and partnership structure? There's a lot
Yeah,
to talk about here.
great, absolutely. I think it's really important to emphasize that the day to day that Ryan's just discussed, that's the sort of practical, tangible aspect of it all. But there's we've already discussed the partnership structure a little bit, so I'm going to focus mostly on culture. Culture is just a really vague idea, and it's very, very difficult to pin down exactly what it means, but it can mean so many different things for so many different firms. But the important thing is that you can get all of the financials in place, you can figure all of that out, you can make sure that your systems are all aligned and everyone's on the same, case management system, everyone knows what emails systems they're going to be using, all of that. But if there are some like fundamental cultural differences in the way that the firms, talk to their clients, reward partners, expect work off of you, then that's going to cause friction. I think there's like a really famous quote from some business person saying culture eats strategy for breakfast, which essentially means that it doesn't matter if your strategy is perfect if there are certain differences in the way that you just do your work and you collaborate, then that's going to cause problems. So what can cause problems? Firstly, there are just differences between, in the case of the three mergers that we've discussed, the US and UK, differences in working styles. One of the classic jokes that everyone always says on the US side is, God, these European lawyers, they're never working. When they have to work with their UK offices, they're like, I don't think that's true, but it's a stereotype that gets thrown around a lot. So there's differences in, I guess, billable hour expectations. That's not so much cultural in the sense that there is a tangible thing it's tied to, but, are you going to impose billable hour targets on your lawyers if one firm has it and one firm doesn't? And that's going to create a different kind of culture of trying to strive for billable work. The thing that you hear is that if there's a really high target, more senior associates are not going to delegate some billable work to their junior counterparts because they want to keep that billable work for themselves, and it might cause more competition. And a more competitive environment is a very different one to a firm that doesn't have any billable targets and is a little more collaborative in that sense. And then there's the sort of partnership compensation. Is your firm going to integrate a eat what you kill model? That's a very US thing to do. The more business you bring in, the more highly you're going to be compensated. Or are you going to stick more with a lockstep model? And both of these practical considerations create very different cultures. Once again, a difference between the more competitive, perhaps more confrontational and aggressive style of an eat what you kill model versus the we're going to earn the same amount for the foreseeable future, so we may as well help each other out. Idea of the lockstep. And then there's just working styles. How do you interact with your clients? Like, how often are you expected to respond to emails, or, are you more casual with them? Are you quite formal with them? What are the norms on that front? How do you collaborate with your colleagues? Is it normal is it an open plan office? Has it been an open plan office in one firm for a long time, so you've been able to literally sit down next to a partner and have a chat with them? Is it a little more segmented? Is there no open door policy? Is it all a little bit more hierarchical and traditional in that sense? How are those, niggles going to be ironed out in that sense? And also, differences in culture are felt most keenly when you're quite junior, because you're at this firm and you've got nowhere else to go, perhaps, potentially, and you're just starting out your career. A partner will have their client base, and if they don't like the way that things are going culturally, they can just leave, and that's a real risk for firms. So you need to be able to the two merged firms need to be able to iron out all of these kinks quite early on, because otherwise they're at risk of losing their moneymakers. And yeah, and obviously if it's not an equal merger, so if it's more of an acquisition, and that's a very fine line, you can run the risk of making the smaller firm just feel like they're being absorbed, and they have to conform to all of the, like systems, as Ryan's mentioned. They have to take on they have to relinquish leadership, they have to do all of this, all of that. And that can cause friction in culture as well. Yeah, so it really does just depend on these very vague ideas that are tied to very real structural changes, but they create different vibes, for lack of a better word. And yeah, that can really, really make or break whether a law firm merger works or not. But yeah, I think that's sort of everything that we wanted to cover. If you don't have anything else to add, Brian.
Just touch on the back of that culture point, sorry to talk about myself again about my
Bring us that
merger.
insight.
Well, I think and it's not really very law related, but one of the biggest kind of challenges of a merger is obviously is that culture point, and it's always something that's so hard to grasp. I mean, people always ask about in relation to training contract interviews, how do you describe a firm's culture? It's very abstract. It's very difficult to pin down and talk about in very concrete terms. But one of the difficulties I say experience, we definitely got over it, and I would commend the firm I was at for doing so, is that when you first merge with a new firm, it's like making a new friend. It's a bit awkward. You don't know anyone else from the new firm. You're in the staff canteen, you're walking about the office, you don't have to say hi, or if it's been too late now post-merger to introduce yourself to new people. Like, it's not the first day anymore, so it's a bit awkward. Um, my team I worked in contentious insolvency, and the other firm didn't have a contentious insolvency team, which meant we were quite insular. We were kind of isolated. It was just us still, whereas all the other teams merged together and got kind of either co-heads of departments now, or their teams just merged otherwise. So yeah, one of the things that I found was it was a few weeks after the merger, we moved into a different office. And the thing that kind of brought us together was actually like icebreaker events and staff events, like going to the pub, or if people don't drink, doing a games night or anything like that. Just opportunities to go and meet your new colleagues, to kind of break those barriers. Because otherwise it's just awkward, and that leads to problems with like knowledge sharing and who you feel comfortable to approach to ask for advice. If you've got like a completely new like partner who's in charge, and say your partner's off that you used to work with, you might just feel not as comfortable approaching if you already established a rapport and a relationship with one of the people. And B, as you mentioned, with like partners and partners being able to leave and stuff like that. Definitely not a big thing at my firm, but with US firms is like I think it's called like origination credit, where like you get so much like money for bringing in your own clients. You might be kind of less willing to dish out instructions that you can't handle to people from the old legacy firm, because you don't know them as well, or you're just not friends with them yet. So taking those steps when you first merge and like doing little celebration events. I know they've celebrated 1 year anniversary a couple of days ago and did like a big event for it. And obviously that just helps the whole firm merge even more and they look really, really good and happy together now, like a happy marriage. I think it's just important to have that, us and them culture and try and just get all these kind of fun things, I guess, in place, fun corporate events to integrate into one culture. But yeah, that's all I got to say on the culture point. There is a lot of challenges we've covered today, and in fact, there'll be even more that we haven't discussed.
Yeah.
There'll be tons. Mergers are very, 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 very complicated. But I know you said you're done if you unless I have anything else to add. Do you have anything more to add on top of that?
No, thank
The
you.
cherry on top of the cake.
Thank you for giving us all of that. That's helpful to know. I mean, it's literally just like, just think about it in the sense that if you're smushing two massive groups of people together, it's just gonna it's gonna take some time. But thank
It
you
is.
everyone to listening to this week's episode. We hope you enjoyed it and found it helpful. We'll be back next week with another episode. And yeah, so stay tuned for that. You can listen to this episode on YouTube, Spotify, or on Apple Podcasts. Thank you.
Thanks for listening, everybody. Bye bye.
The Legal Cheek podcast is sponsored by Simpson Thatcher, home of the private equity training contract.